the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. With me on the panel for all 6 cases we will be hearing this morning. To my right and your left, Justice Ken Desmond. To my left and your right is Justice Catherine Hand. The first 4 matters on for hearing this morning are criminal matters. We will hear those in succession and then take a brief recess and resume the session with the remaining 2 cases, both of which are civil. Those of you who have been here before know the drill. Each side of the V has 15 minutes to argue. If there's more than one side arguing on either side of the V, please let us know ahead of time how you'll be dividing your time. There is no rebuttal. The panel are familiar with the arguments that you've made in the brief, with the facts, the procedural background. You needn't repeat or recite all of that. We will have questions for you. If you reach the end of your time before you reach the end of your argument, you may rely on your brief for whatever remains. And if you reach the end of your argument before you reach the end of your time, of course, there's no need for you to continue speaking. We will have questions for you. We mean no disrespect by interrupting you. We just are trying to get to the points that we were unable to address to our satisfaction out of the briefs. With that, we'll call the first case on the list, case number 2022-P-876, the Commonwealth versus JAVIER Torres.
Good morning, Your Honors. Attorney Dana Gravina on behalf of Mr. Torres. We're here today due to a motion judge's denial of a motion for new trial in which Mr. Torres alleged that he was deprived of the effective assistance of counsel at the time of his plea in this matter. Mr. Torres had admitted to sufficient facts for a finding of guilt with respect to a charge of distribution of a Class A substance. The motion judge agreed with Mr. Torres' affidavit and the motion judge's affidavit and found that at the time of that plea counsel had not advised Mr. Torres of the immigration consequences of his plea. So the sole question before the court today is whether or not the motion judge was correct when he decided that Mr. Torres had not established the prejudice prong of the ineffective assistance of counsel test. Mr. Torres' position is that he had substantial connections to the United States at the time of his plea, such that it would have been entirely rational for him to refuse to tender a plea and go to trial. Mr. Torres, at the time of this plea, had resided in the United States for 9 years. He was born in the Dominican Republic, but came to the United States in 1990.
At that time, how old was he?
I believe he was in his late 20s, Your Honor.
So he had lived outside the country as an adult for a considerable period of time before he emigrated to the U.S.
He had lived in the Dominican Republic. It may have been his early 20s when he arrived. I mean,
and just to go back a little bit in your argument, we're not simply dealing with the second prong prejudice piece of the analysis here, but specifically zeroing in on the special circumstances aspect of that prong.
That is correct.
It is routine for defendants to have ties to the community. The question is whether it would have been rational, whether the circumstances are so compelling. And the cases, if you look at the cases that have found special circumstances, typically it's someone who has lived substantially their entire life in the United States from a very young age and has no connection to the country of origin.
Your Honor, what I would say to that is that Mr. Torres had not been here for just a matter of a few years at the time of this plea. He had resided here for 9 years.
What was the disposition?
It was a continuance without a finding.
With no time served. And had he gone to trial and been convicted, he would have faced a mandatory minimum?
That is correct. Mm-hmm. And it's not only, Your Honor, that he had lived here for 9 years, it's also that he had become a legal permanent resident for had been a legal permanent resident for 5 years. He actually he has 2 U.S. citizen children who were one of whom had already been born and was residing here in the United States. His brother and sister were also residing here in the United States at the time of his plea, and he already had established a career here in the United States. He was working as a welder at the time of his plea. This case, Your Honor, is also one where Mr. Torres had a valid defense that he could have put forward at trial.
Well, reasonable minds might differ as to that. I mean, the police officers said that they saw the hand-to-hand, they knew the buyer or the person who received the drugs. They stopped her, they recovered the drugs, and they said they weren't that far away. So if you find them credible, then the defense really wasn't that strong.
The police officers alleged that they were approximately 20 feet away. And so I believe that Mr. Torres would have had a very valid defense at trial.
Would have had a triable case, but his prospects were not promising.
I don't know that I would put it there either. I think that his prospects...
Are we 20 feet from each other right now?
Excuse me?
Are we 20 feet from each other right now?
No, we are less than 20 feet from each other.
A little bit more than a free throw, but less than 20, but pretty close to 20.
I would say we're probably need to about double the distance we are from each other, and from that distance to be about 20 feet, and to be that distance away and to see 2 very, very small glassine bags handed from one person to another, I would say is a bit of a stretch. And I think that a very compelling case could have been made to a jury that that was in fact the case here.
And so it would have been rational for him to roll the dice on a mandatory minimum rather than to get a disposition with no time served.
Absolutely, especially considering the fact that this case is different than Commonwealth versus Clark.
Is that what you advise your clients in this circumstance if they have a similar plea, immigration consequences aside?
Absolutely. If this was my client, he would have gone, and he followed my advice, he would have gone to trial. There were no narcotics found in the vehicle. There was no money found in the vehicle. There were no cell phones found in the vehicle or on Mr. Torres. There was nothing here at all in terms of evidence against Mr. Torres other than an officer's claim that from 20 feet away he could see Mr. Torres hand 2 very small glassine bags to another individual who was standing on the street. That, I would say, is a very, very triable case. And if my client, his prospects were that he could either go to jail for 2 years and then be deported,
No. I'm talking about immigration consequences aside. You would try that case.
I would try that case.
For a defendant who walks with probation and no time served, rather than facing 2 years of mandatory minimum.
For someone in Mr. Torres's position...
No. I'm talking about the forecast of the likelihood of winning the case, getting a not guilty. You're going to tell a client who's not facing deportation, I would go to trial.
Maybe I'm overconfident in my trial abilities, but I would try this case. I would absolutely try that case.
You would advise your client?
I would advise him that he has a trial. I never advise my clients whether to go to trial or not go to trial, but I would certainly advise my client that this is a case that is a triable case. Absolutely. I believe a jury is smart enough to know that from 20 feet away, an officer cannot see 2 very small glassine bags being passed from one person to another. I believe that given the fact that he had nothing on him, he had no cash, he had no cell phones, he had no drugs, he made no incriminating statements, that absolutely that is a triable case.
Buyer make any statements, or the person who received the drugs make any statements when they stopped her?
That would not be admissible at trial unless she testified, and there's nothing to suggest that she would have been called as a witness and would have done so. She had a valid Fifth Amendment privilege and would have been entirely reasonable to assume that she would have asserted that and would not have testified. In addition...
Did she make any statements when they stopped her, I asked?
She made a statement that she had bought it for her friend, but she didn't make a statement that she bought it from Mr. Torres. She just made a statement, I bought it for my friend. She didn't say, I just bought it for my friend. And so...
Was she charged?
That I do not know, Your Honor. I do not know that.
They were familiar with her, right?
They knew her. Correct.
They knew that she used.
I'm sorry?
They knew that she was an addict.
They did. We are not, though, talking about someone that is a United States citizen and whether they would have tried this case or not. We are talking about someone who is not a United States citizen.
No, but the prospect of a not guilty, which you have elevated to a level that's higher than I might, if I were looking at the same facts, bears on the question of whether it would be rational for someone who is facing deportation to roll those dice.
It does, Your Honor, but at the same time, the case law bears this out, that someone can be facing an incredible amount of evidence against them and an incredibly long jail sentence if convicted after trial. But the prospect of being forced to return to their native country.
What is the case that has found special circumstances that, in your view, has circumstances most closely resembling those in which this defendant found himself at the time of this charge?
The Ortiz case, which I cite in my brief, is a similar case.
I thought Ortiz was 3 years old when they came to the country.
He was also from the Dominican Republic. He was facing similar.
That had no ties, no identifiable ties whatsoever. Had lived substantially his entire life and the entirety of his childhood, adolescence, and adulthood in the United States without any identifiable ties in the Dominican Republic.
But, Your Honor, I don't think that should be the cutoff of you had to have come here as a child.
I'm not asking what you think. I'm just asking for the case that most closely resembles. And
I don't know that.
I don't consider Ortiz to be all that close for the reasons I've identified.
But in the Ortiz case, there's some things that are here that weren't there, such as the fact that Mr. Torres had a United States citizen child who had just been born. Perhaps to him, at that time, it would have been more important to take his chances and be able to reside here in the United States and raise his child than be deported back to the Dominican Republic and be separated from his child.
No barrier to his child going with him to the Dominican.
Well,
child can travel freely throughout adulthood.
But presumably, Mr. Torres had made the decision that life in the United States was much better than life in the Dominican Republic.
He also made the decision that life outside of incarceration was better than life in.
And isn't that a rational view, given that he had just had a newborn, and who wants to go to prison for a mandatory minimum, having just had a newborn?
Well, I think that if you were to look at the situation and say, I can spend 2 years in jail and then be deported, and I will therefore be away from my child. I'm not going to bring my child to the Dominican Republic. I want my child to be a United States citizen. I want my child to reside in the United States. So therefore, I can take my chances, and if I lose, then I get deported after I do 2 years in jail. Or I can just sign up and say, deport me. Send me back, and therefore I have no chance whatsoever of ever being able to reside in the United States and raise my child. I would say in that circumstance, it's entirely rational to say, no, I'm going to take my chances. I'm going to take my chances, and if I lose, then the same thing will happen. I can either sign up today to be deported, and either have to leave my family or have to bring my family to the Dominican, which is a place that I've decided I don't want to reside in and is not good for my family, or I can try. I can fight this. And the worst case scenario is I do 2 years in jail, and then I'm right back in the same position that I would have been in anyway.
But that's not what happened, right? We're talking about it 20 years later.
Correct, because he never was made aware of the fact that this is what he was signing up for. He was signing up for deportation. And so had he been given that choice, that decision, I would state that someone who is a 5-year legal permanent resident, who's resided in the United States for almost a decade and has a young child who's a United States citizen, has a brother and sister in the United States, would say, no, I'm going to take my chances.
What prompted him to bring the motion now?
The fact that he does have immigration issues.
Why?
I believe it stems from I'm not his immigration attorney, so
I'm not asking you, are you his immigration attorney? I'm asking you, what prompted him to bring the motion 20 years later?
I believe it is to avoid immigration issues at this
And what
point.
triggered that?
It is not a new offense. I can say that for sure. Has
He had any subsequent offenses since this plea?
He had 2 other cases in Massachusetts back in the early 2000s.
For dealing drugs?
They were also narcotics cases. But I would say to Your Honors that just as his current circumstances, his subsequent circumstances to the plea aren't taken into consideration in determining whether it would have been rational to go to trial or plead guilty at the time of the plea in 1999, that anything that happened subsequent to the plea, such as new offenses, also has no bearing on whether or not he would have pled or not pled in 1999.
Just one point of clarification. The motion judge in the memorandum of decision stated that he was a legal permanent citizen, and I take it that was a misstatement, that he was a legal permanent resident at the time.
That's correct. He's a legal permanent resident.
Could I just ask a couple of just housekeeping type questions? This was a non-evidentiary hearing,
It was a not evidentiary hearing.
and were there signed affidavits? It looks to me like the affidavits in the record are not signed, but it wasn't raised. I'm assuming that there were signed affidavits that were submitted.
There certainly were signed affidavits that were submitted. If in the record they're not signed, then they are signed in the clerk's office. I'm sure of that.
And was the motion judge also the plea judge?
He was not.
Okay. All right, thanks.
Anything else?
If there's no further questions, I'll rely upon my brief.
Thank you.
Thank you.
For the Commonwealth?
Good morning, Your Honors, and may it please the Court. Erin Knight on behalf of the Commonwealth, asking the Court to affirm the denial of the defendant's motion to withdraw. I want to start off with the special circumstances and the particular emphasis component. When looking at the special circumstances prong of the test, it's a focus on the time of the plea. So that he has 2 children that are now in their early 20s has no effect on that. What would have effect on that is the 1 child that was born possibly right before. But if you're going to look at his children, his work history at the time of 1999, you also have to look at the fact that he was again convicted in 2005 by plea in both Essex and Suffolk Superior Courts for trafficking charges. At that point, he had both children. So it's clear that the children were not a factor in his decision to plead because he did it again.
Wasn't the argument then that the damage was already done? He already had a deportable offense at that point?
Well, I would argue to the Court that if he already had a deportable offense and the 2005 cases were just, why not add him on? I don't think that's how it works here. I think here it's clear that he continued to unlawfully perform these behaviors, but he also would have had 2 more chances at the plea to have that immigration advice given to him by counsel. We don't know. He hasn't filed motions. But we also have 3 times that in the usual course, he would have been given some sort of alien warning by the judge, which should have triggered something at that point. So I would say that waiting 20 years after this plea, where he, in the usual course, would have gotten an alien warning, but we don't know because we don't have the transcript of the actual hearing. But when the court looks at it, they presume it's in the normal course. And then in 2005, twice, 2 pleas, he would have also gotten said alien warnings from the judge in the usual course. I would argue that that there would have triggered something much before 2021 when this was filed. I think, we do know that in context of immigration that these warnings are given by a judge, and that usually that those warnings should trigger something if you are not a citizen.
The statutory immigration warning does not include the detail which I've had occasion to work through myself, and it's not for the uninitiated to know what is and is not a mandatory deportable offense.
That is accurate, Your Honor. It does not. It does not
put. Is that the key ingredient that bears on the choice that someone needs to make, and that relies on the advice of counsel?
I would agree to you to the extent that that would obviously weigh in on the choice, which is why the judge did here find ineffective assistance of counsel on that first prong. However, just the argument, just the notification of if you are not a citizen of the United States, something is going to happen.
Could happen.
Could happen.
But that's the.
Practically
that's what
inevitable
the is all
language.
about, right? This is not something could happen, this is something will happen.
Correct. That, while that may be true, we still go to that second prong of prejudice. And here, he didn't have a defense. The judge found in his findings of fact that the officers saw what they saw. He didn't provide anything that would say that the Commonwealth would have provided a better plea agreement than the one that he had gotten. They had already agreed to a 1-year suspended sentence, dropped the minimum mandatory of the school zone, and dropped the conspiracy charge. And as you pointed out, Your Honor, earlier, if he had gone to trial, he would have faced deportation with a guilty anyway. So again, with that rational under the circumstances view, and in the totality of, yes, he has kids, yes, or had a kid at the time, yes, he had a job, yes, he'd been here. He was 23 when he came in 1990. It was 1999 when he pled. You'd still take all of those in context of the Commonwealth's case, the totality of the circumstances of everything that was surrounding him, including inevitable deportation and jail time, a mandatory minimum if convicted. I would also say that
He didn't aver that he was going to be returned to like a war-torn country or anything of that nature, did he?
no, and I think, Your Honor, that actually puts us squarely outside of many of the special circumstances case, especially if you look at like Commonwealth versus List, for instance. He was 10 or 11 when he came, I believe. He had no more family ties whatsoever. He had lost all his family ties when Haiti had the earthquake. He had a learning disability. There are many more things there that would put him squarely into more of a substantial connection, more of a reason to put that particular emphasis on immigration consequences than the defendant has averred in his affidavit here in this case. If the court has no further questions, I would just point out that, again, it is a rational under the circumstances review. We're only looking at those special circumstances here, and I would argue that the judge was very sound in his reasoning to deny this motion.
Thank you.
Thank you.
both. Case is submitted. The next case on our list. I did. Next case on our list for hearing is the first of 3 related juvenile cases. The names of the parties are impounded. These 3 cases involve juveniles who were tried together on separate offenses as co-defendants, separate offenses arising out of the same underlying set of facts. We will hear argument in each of the cases separately and serially. I would encourage counsel in the succeeding cases not to overlap unduly. The facts relating to each of the 3 defendants are slightly different, and I think it's important that we focus in on any differences that those different facts may make on the issues on appeal. The first of those cases is case number 2022 P787. You may begin.
The timer, sir.
Okay. We set the clock. There we go.
Good morning, and may it please the court. Eva Jellison on behalf of the juvenile. He would have been here today, but he had work, so he'll be watching the argument later. To quote the First Circuit, in our society, police officers are expected to endure significant burdens caused by citizens' exercise of their First Amendment rights. Indeed, the freedom of individuals verbally to oppose or challenge police action without thereby risking arrest is one of the principal characteristics by which we distinguish a free nation from a police state. And this case is about police overreaction and police overreach in response to my client's exercise of his First Amendment rights. And it should have ended with his motion to dismiss or motions for a required finding. This is because one of the elements of resisting arrest, the color of law element, includes the following. The officer must have made a good judgment in good faith based upon the surrounding facts and circumstances that an arrest should be made by him. And although there's no definition in the statute as to exactly what that means, I offer that it should mean that the officer made a judgment based upon an honest belief and absent malice that in the surrounding facts and circumstances, that he had probable cause to make an arrest, meaning that it was a lawful arrest. And I take that from Commonwealth versus Keough, in which this court observed, that if the officer knew that he was making an unlawful arrest, it would not meet that color of law element.
So assuming that that's correct, is it your position that there is, using the very Commonwealth favorable standards that apply in both instances, that there is no basis on which a reasonable fact finder could find that good faith belief on the record that was presented first at the motion to dismiss stage and then secondly after the Commonwealth's case?
Yes, Your Honor.
Okay, can you explain that a little bit?
Absolutely. I'd like to start with the trial evidence. I know that was my second issue, but I'm going to start with the trial evidence. So the trial evidence was this. The arresting officer for my client was Officer Vaughn. Officer Vaughn saw very limited conduct from my client. My client, he had just forcefully arrested Juvenile AD. And when he finished that arrest, he looked...
Just interrupt you for a minute. Was Officer Vaughn the school officer?
Yes, so Officer Vaughn was a school officer and Officer Parrott was also a school officer. And Officer Vardaro at that time was also the commanding officer of the school officers. So many of them were school officers.
And had there been some actions earlier in the week prior to this particular day that may have been in their mind when they addressed this situation?
There was evidence that there had been some fights earlier in the week. There was also evidence that there were no fights in the immediate vicinity of these juveniles.
I understand, but I'm just trying to figure out, as we put things into context, what was in their mind that when they headed out to, I don't know if it was Florence Street or whatever the first
This
street
was Florence Street.
What
Yeah,
was
there
the
had
first
some
street that they were on?
Forest Street, so Forest Street is the street that Brockton High School is on. Florence Street is a couple streets over. So there had been some fights on Forest Street, and apparently there was one that day. But I will note that Officer Vardaro testified that there were no other arrests made on the day of this incident. So there were no other incidents for which they found probable cause to arrest juveniles.
Okay, got it.
No other incidents where they acted upon probable cause. Whether there was probable cause to arrest or not, we don't know.
Sure, I said that for which they found. So for which they acted on, sure.
But the question is whether there was probable cause or a good faith basis to support a belief that there was probable cause here.
That's right. And I'm going to go back to Justice Hand, who was asking me about the evidence for this particular juvenile. And Officer Vaughn, gets up from his arrest of AD. My client is 10 feet away from him. He tells my client to leave the area. My client says, I'm not leaving, we're not leaving, F you. That was the conduct. It was at that point that Officer Vaughn testified that he decided to arrest my client and informed my client that he would be arresting him. So that was the limited conduct. My client was standing 10 feet away from him. He said he got a little bit closer during the verbal exchange, but that was the conduct. I'm not leaving, we're not leaving, F you.
When he said we're not leaving, who was he referring to?
I'm sorry, I can't hear you, Justice
When the
Stedman.
person said this is RE we're talking about, correct?
This is RE.
And when he said we're not leaving, who was he referring to?
I assume he was referring to other juveniles. There was evidence that he was with DJ for the majority of this incident. There was evidence that Officer Anderson saw him and DJ filming the arrest, Parrott arresting CC earlier, and that he continued to observe and film with DJ. So I assume that he was talking about students in the immediate vicinity.
There were quite a number of students in the immediate vicinity, right?
There were, but I think it's really important, and I included this in my brief. There were motions for required finding for my case, both after the Commonwealth's evidence and after the defense evidence. And I think to the extent that the court is going to rely on the number of students or kind of the scene as a whole, I would invite and encourage the court to watch the video, because it's very clear that there were two officers that testified that in the immediate vicinity of that this was all occurring with the juveniles that are involved in this case, that there weren't very many students. Two officers testified to that. That was Officer Benoit and Officer Anderson, and their testimony was 100% true. That testimony was 100% true because in the video, we see that there were more officers than children in the immediate vicinity of this. Now, were there other children on the street, further down the street?
When you say immediate vicinity, I mean, what you're talking about is a narrow lens, right?
A narrow lens, but I think that it is a sufficient lens to talk about because it's the area of an entire front yard in the city of Brockton. So the entire front yard and then the street in front of that front yard, perhaps a bit into the next front yard. But for example, if Officer Vaughn had testified that my client was somehow, if this was true, he could have testified that my client was endangering officer safety because he was too close, because he and a group had surrounded Officer Vaughn. Officer Vaughn didn't testify to that with regard to my client anyway. He did testify that there were a lot of students around him when he was engaging with AD, but the video shows that that was clearly false. He said that there were...
The video is a little hard to evaluate because it is a short clip. It doesn't show what it doesn't show.
Absolutely, absolutely.
To go back to the phrase that we mutually adopted a moment ago, it's a narrow lens.
Yes, but Officer Vaughn's testimony about what was going on that would have made this a more chaotic scene was untrue if you watch the video. It was untrue because he testified that when he was engaging, right before he was engaging with AD, when Parrott was arresting CC. And this has some to do, but not as much to do with my client, quite frankly, because this all occurred before.
Before we go too far down the path of an argument resting on the assertion that the officer's testimony is untrue, I want to make sure that we are squarely grounded on our standard of review. So right now we're talking about the trial evidence.
Yes.
And for that purpose, we view the evidence in the light most favorable to the Commonwealth.
Correct.
And so when you describe testimony as being untrue, that takes you outside of that standard, doesn't it?
It does not. The deterioration standard is that if it is conclusively established that evidence that the prosecution...
So what you are then saying, it seems to me, is that the video demonstrably establishes that the officer's statement was false.
Yes, certain of the officer's statements, and I detail that in my reply brief. The end of my reply brief is a series of Officer Vaughn's statements that are conclusively established to be untrue by the video. I'm not saying that all of his statements are conclusively untrue. They're not on the video. But the ones where he says that during, and that's why I went back to this arrest, the one where he says that there are hundreds of students surging in and that he's holding back students are conclusively untrue. They are not on that video. And you have a perfect view...
Those are two different things.
...of Officer Vaughn.
The fact that they're not on the video doesn't mean that they didn't happen outside of the brief period that's depicted on the, or outside of the brief, the narrow location.
I think we're actually in agreement, Justice Green. I am not saying that nothing that Officer Vaughn said, like that Officer Vaughn was entirely lying. What I'm saying is that in the moments that you can 100% see where he said that something happened that did not happen, that conclusively establishes that it did not happen. And that's what I'm resting on. But I don't need that deterioration argument. I really don't. Officer Vaughn should have been able to distinguish between people who were exercising their First Amendment rights and people who were not in that situation. And all he saw from my client was that my client was observing him make a very forceful arrest of another student. And my client said, I'm not leaving. I am bearing witness.
You're not leaving.
We're both. I'm not leaving. We're not leaving. We are bearing witness to your violence. We are bearing witness to your violence, and F you. And that is protected by the First Amendment. It is conclusively protected by the First Amendment. It is clearly protected by the First Amendment. It is in decades-old case law from the United States Supreme Court that you can criticize.
Those cases are incredibly nuanced and fact-intensive. And the circumstances, the dividing line between free exercise of free speech and incitement in a volatile crowd is difficult and challenging to those of us who wear black robes. To people in the field in the moment, developing a good faith belief about how best to stabilize the situation, it's a different question, it seems to me.
Can you help me with this question also? Assume that there's enough evidence for us for a fact finder in this case to have determined that there was a crowd and that the crowd was tumultuous in some way, and that the issue was not what words were said by your client, but rather Vaughn's telling your client to leave this gathering, would that not provide a good faith basis for probable cause if what the officer was doing was trying to disperse a member or more than one member of this crowd?
So no, not on the facts of this case, and I would point the case to Commonwealth versus Markavich. In that case, the police officers had instructed a man who was protesting at a Halloween celebration in Salem to stop using a megaphone. And what the court said that was very important is that the order did not wholly preclude him from exercising his First Amendment rights. He was still able to speak. They didn't tell him to leave the area. They told him to stop using the megaphone because that would have lessened the public safety threat. So in this case, Officer Anderson did the right thing in this case. Officer Anderson testified that my client was filming the arrest between CC and Parrott, and that when she asked my client to move back to a safe distance, he did. And that would have been a proper order from Officer Vaughn as well. But and
Those cases, the cases that you're citing, when I looked at them, they by and large seem to me to be cases testing the sufficiency of the evidence to support a conviction, not cases focused as we are here on the separate question of whether there was probable cause in the circumstances to support arrest, much less a good faith basis that there was probable cause.
Well,
do you have anything in this context or adjacent that examines this specific question?
So the only real case on this element is Keough. So I don't have any case on this element of a resisting arrest, the color of law, and therefore is Keough. So I would point the court to Justice Green, if you don't mind. I would point the court to Glick versus Cuniff, to Glick versus Cuniff, which, now this is a qualified immunity case, but I think that there's a corollary here. If you do not have qualified immunity to arrest someone who's exercising their First Amendment rights, who's taping an arrest, who's observing an arrest, who's collecting information about an arrest, how can you have probable cause to arrest them for that conduct?
So some of the cases, it appears to me, that hinge on, kind of a peaceful protest. You cite the Salem case where they were protesting whatever was going on. But here, that's not what's happening, right? Here, the police are told that there might be a fight. They respond to hundreds of kids in the street. There's no protest. There's no peaceful protest. They're asking them to disperse. They're refusing to disperse. And things escalate from there. So what's the protest?
For me, there could be no more important protest at this moment. This is 2019. My client is a black teenager in Brockton. The testimony is that there was every available police officer in the Brockton police force and the Brockton school police force that were converged upon the school that day as he left school.
Why?
As he left school, he doesn't know why.
I'm asking
he
you,
sees
do you know
this
why?
huge.
Why did they do that?
There had been some fight. I don't know if it's in the fight. It's in the transcript. There had been some fights. Okay. So huge police presence. My client is walking home from school. In his community, this huge police presence, his response to that is F the police.
I'm going to walk in the street, I'm going to interrupt traffic, and I'm not moving.
So his initial response to that is F the police. He's walking on the side of the road. Officer Parrott stops his cruiser. Officer Parrott gets out of his cruiser.
I get that.
Officer Parrott aggressively confronts my client.
I get that.
But my client, walks away. This is just my client.
What are the police to do when there are hundreds of kids in the street disrupting traffic and refusing to disperse? What are they to do?
So I know my time is up. May I finish? For my client, he is approached by this officer. He then sees that officer hit a phone out of DJ's hand 3 times. He sees violent arrests, 2 violent arrests, and he is bearing witness to that.
You can continue speaking if you answer Judge Desmond's question.
No, I really am trying to answer Judge Desmond's question.
You're talking about what your client was thinking. He's asking, what are the police to do?
The police are not to arrest students.
What are they to do?
They are not to arrest students who are exercising their First Amendment rights. They are to give lawful orders like back up to a safe distance.
Thank you. Thank you. For the Commonwealth.
Good morning. If it may please the court, Elizabeth Mello Marvel for the Commonwealth. Your Honors, it is the Commonwealth's position that there was sufficient evidence in the probable cause standard, both at the motion to dismiss based on the the complaint as it was written, laying out the facts, establishing resisting arrest, as well as the trial stage. In looking at the facts of this case, it's very easy to look back in a courtroom, in a safe environment, but it's important to look at the entire context of what the officers were responding to and the testimony that came out and what the jury heard.
Let me ask you this
apologize.
question. Had the officer not got out of the car to challenge the kid for saying F you, would we be here today?
That's speculation, perhaps.
What do you think? Why did he get out of the car to challenge the kid for saying F you to the police?
I guess we would have to ask him in testifying, but it's a little bit dangerous, respectfully, Your Honor, to engage in speculation of what people could have done. What if the juvenile had walked away when he was asked to? What if the other children had walked away when they were asked to? This 17-year-old juvenile refused. Juveniles were in the street, blocking traffic, yelling at passing motorists. One boy was assaulted on another street, and they responded to that. One of the officers responded that, testified that when he responded trying to get down the street, he had to drive 5 miles an hour. He couldn't get through the crowd. He then had to get out of his cruiser and walk to get closer. They were having difficulty talking to each other on the radio because it was so loud. This was a very chaotic scene. What would have happened if he had not gotten out of that car? I don't know. I can't speculate. I can't predict. All we can deal with in the question here is, was there sufficient evidence for a rational fact finder to find the elements of the charge? And based on the testimony as it came in, is the Commonwealth's position that there was, and that they were the fact finder to weigh the credibility in looking at the video as well as all of the testimony. Again, the video, very narrow in space and time, shows but a snippet, a very brief snippet, and has no sound, so you can't hear the interaction between anyone. And this is not a situation where officers were just indiscriminately arresting people
Attorney
for...
Marvel, I'm sorry to interrupt you, but could I ask, what are the crime or crimes that the Commonwealth says there was probable cause to arrest for? Overlooking the grammar of that question.
Your Honor, I believe that they would have believed that they had a good faith basis for disorderly conduct, tumultuous behavior, endangering public safety, that they would have had a good faith basis to believe that. They were asking everyone to leave, to move along so that cars could get through, so that it was a safe environment, so that there wouldn't prevent anyone from getting injured or having any more interaction. They already had one boy that had been assaulted. They had an officer that was injured. It was perfectly reasonable for them to ask to move along, everyone to just get out of the area.
Does that probable cause to arrest extend to everybody else that was part of the crowd?
That would be a determination that the officers would make. However,
I'm just asking you whether, had the officers chosen to arrest each of the other members of the crowd, whether they would have had a good faith basis for those other arrests.
Perhaps, depending on what the individuals were doing, we would have to look at fact-specific.
Not dispersing.
For not dispersing?
Right.
Potentially, depending. Were they blocking traffic? Were they screaming at a motorist? I mean, you had individuals citizens that couldn't pass through. So it would depend if they were just walking. What do we mean by not dispersing? Were they just walking slowly and kind of taking their time? Or were they turning and challenging the officers, as some of them described happening? It was a volatile situation. Again, we're speculating, and really the issue here is, was the evidence as it came in at trial or was put forward in the complaint sufficient? And that's the issue that's before your honors today. Again, Commonwealth's position, looking at the evidence, that it was sufficient.
And was it the individual's words, in this case, specifically what the individual said, that was a basis of the crime, or the fact that he was there and not dispersing, or some other reason?
I think it's a factor. I think you have to look at it in the totality of the situation. It has a very different feel to have to say to a citizen, when you have these factors that we're talking about, and to say to move along and to maintain order and safety, and to have someone turn around and respond, F you, we're not leaving. and while another officer is trying to arrest someone, another officer's injured. These are all the factors that are going on at the same time. So I think it's you can't look at it in piecemeal. You have to look at all of the evidence, and I would say that it potentially could, depending on all of the factors.
Well, the other officer being injured, they weren't aware of that at the time, right?
We don't know. We don't know. One of the officers testified.
In your brief.
I apologize?
It doesn't appear that way in the brief. It sounds like they learned afterwards that the other officer had been injured.
Okay, I stand corrected then, Your Honor. My recollection was that there was some testimony about one of the officers staying with an officer that was injured until they received treatment, and then going on to interact with some additional juveniles. I don't recall which juveniles specifically, but he did stay and respond, so he would have known at least that there was one injured.
We'll have to look at that.
I appreciate it. If there are no further questions, the Commonwealth would rest on its brief. Thank you.
Thank you. The next case, again, involving a juvenile, it's impounded, and it arises out of the same factual episode, case number 2022 P897.
Good morning, Your Honors, and may it please the Court. Melissa Celli here on behalf of...
Just a moment, we need to get the clock running.
Oh, yes, you do. Melissa Celli here on behalf of the juvenile DJ in this case. There are three reasons why my client's arrest and conviction or adjudication must be reversed. First, as Attorney Jellison detailed in the last case, there can be no crime of resisting arrest if the Commonwealth did not prove beyond a reasonable doubt that the officer had a good faith basis for making that arrest. In fact, in DJ's case, the facts are even more compelling than they were in Attorney Jellison's case. And Officer Parrott, it is clear, was not acting in good faith when he slapped her multiple times. Second, the trial judge, even if there is arguably a showing of a good faith basis, this is the sort of factual question that really needs to be squarely placed in front of the jury. The jury should be the one deciding this. And this is exactly the point on which the judge's jury instructions were flawed. And third, even if there was a finding of good faith, even if Officer Parrott was acting in good faith, my client's actions as a matter of law did not amount to the crime of resisting arrest. And I would like to start with that third issue, if I may, Your Honors. As Attorney Jellison described, there are bigger issues at play in this case. However, my client's case can be decided very narrowly. Even in the light most favorable to the Commonwealth, her actions did not amount to resisting arrest. Not every movement that makes an arrest more difficult for a police officer constitutes the crime of resisting arrest.
So let me just ask you one question, and I'm very sensitive to the broader ramifications of this case, believe me. But that being said, let's assume for the sake of discussion that the officer's testimony, which I believe was she was filming him 5 inches from his face. Is that permitted? For her to be in his personal space and filming him, and he's asking her to not do it, and she continues to do it. Is that okay?
So I'm happy to answer that question, but I just want to make very, very clear that that is not what I'm talking about right now. What I'm talking about right now is even if we say that that was a reasonable basis for the arrest, which is something I am absolutely not conceding, in large part based on the video evidence, which again doesn't show everything, but it does show that, and it shows conclusively that my client is not 5 inches from her
I get
face.
it, but I'm asking.
So again, taking that as true, if we were to assume all of that, and if we were to assume that there was some sort of legitimate basis for this arrest, I'm setting that aside for the moment and saying, even if there was a legitimate basis for this arrest, the conduct of my client, once she knew that she was being placed under arrest, did not rise to the level of resisting arrest. In the resisting arrest statute, not every conduct, not everything. If I just stood here, if a police officer said to me, "You're under arrest," and I stood here mute and did nothing, does that make the officer's job more difficult? Probably. Is it resisting arrest? It isn't. And the reason that it's not is because...
Is that what happened?
Excuse me, what?
Is that what happened?
Well, let me go on for just a moment. I will get to that question if that's okay. To resist arrest, a person must have used physical force or violence against the police officer, or threatened to use physical force or violence against the police officer, or used some other means which created a substantial risk of causing bodily injury. Here, none of that happened. Your Honor was talking about a very specific factual question in these sorts of cases. The SJC has held specifically that resisting arrest and the term resisting is not self-explanatory. There needs to be a factual basis for finding that this violence or this substantial risk was created. So what I'd like to do is, because this is such an, as the SJC says, intensely factual, nuanced inquiry, I would like to take the court through the facts as they were testified to. The officer in question here was Officer Parrott. He made the arrest and he testified. We don't have to speculate about what might have happened. He testified to what happened. He describes it in two places. He says resisting. He uses the word resisting, but we already know from Commonwealth v. Hart that that is not sufficient. Just saying resisting is not enough. So on transcript 2, page 57, he said, "I attempted to put her hands behind her back, and she was pulling away from me the first time, and that's when I placed her on the ground." Or on page 98, he elaborated, "I tried to grab one arm. She yanked away with the camera still going. I tried to put her hands behind her back. She wouldn't." Then, immediately after that, he, quote, put her on the ground. He, quote, grabbed her by the hair, back of the backpack, and pushed her to the ground. Her chest and hands hit the pavement first, and she pulled her hands under her body. He, quote, told her to pull her hands behind her back, and, quote, she refused. So he pepper sprayed her, and he put her hands behind her back forcibly. None of the actions alleged there rise to the level of using or threatening to use physical force against this police officer. Let's bear in mind, we are talking about a 17-year-old child who weighed 110 to 115 pounds versus a 185-pound, decades-old veteran of the police force. In Officer Parrott, as appropriate, testified that she made no threats toward him, so we can't say that the threatening prong was present. He said he did not have any concern. This is on page 95. She did not have a concern that she posed a threat of physical violence to him. That is the violence prong. And this conduct could not rise to the level of activity that creates a substantial risk of causing bodily injury. I did an extensive review of case law on resisting arrest, and the cases clarify two important points. First, they clarify the nature of the conduct that rises to the level of resisting arrest, and I will go through some of the conduct that meets that prong. Second, they also clarify the level of detail and the level of evidence that is required to be presented by the Commonwealth to meet its burden in those cases. And what's notable here is that neither of those things were present. Officer Parrott did not testify that he had hold of her and that she was still struggling. He did not say that the actions lasted for more than a second, or he didn't, I mean, maybe not even a second. He testified he tried to grab her once and then he threw her to the ground. This is not the same kind of ongoing belligerent activity that is characteristic of resisting arrest cases. And this also is an intensely factual assessment. Let's bear in mind that my client had just had this very same officer slap her 3 times. It is reasonable that when he went for her again, some time had passed, so it wasn't like slap, 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 and then he tried to put her under arrest. I just want to be clear. He did slap her 3 times, then they separated for a while. He came back to put her under arrest.
You say slap, or you mean he's slapping the phone out of her hand? Is that what
Yes,
you're
and he
referring to?
testified that he made contact with her as well when he
Her hand went.
when he did that. It is entirely reasonable. In fact, I might say that it is reflexive under those circumstances when someone is coming at you, again, to pull away briefly. That is all we have.
The question of whether it is understandable as a reaction does not immunize the conduct from satisfying the elements of the crime, right?
That is correct, Your Honor. However, what does immunize the conduct is the brevity of that response. If you look at, let me back up and say, it is easy to look at blurbs from some of these cases.
Well, I'm reminded of a case that I didn't author the case. I was on the panel, but very, very early during my time here with Judges Cowan and Mills, Commonwealth versus Keough.
Yep, I have that case.
You're familiar with the case. And in that case, the defendant stiffened his arms in order to impede the officer's attempts to place him under arrest and put his arms behind him. It's use of force, not an act of violence, that satisfies that prong of the resisting arrest statute.
That's correct, Your Honor. And notably, it is use of force against the officer.
I understand that,
And
but pulling away
May I?
in opposition to the officers, you may in a moment. Pulling away from the officer's attempt to effect the arrest is the use of force against or in order to impede the successful execution of that effort.
It is not. You are not using physical force if there is a swing and a miss. That is not.
If there is what? I'm sorry.
If he reached for her and did not grab her, there is no force against the officer. It is, yes, possibly.
Oh, but if he has her arm in his hand.
But that's not the testimony.
If he has her arm in his hand and she pulls away, that's the use of force against the officer, correct?
Possibly, yes. But again, that is not the testimony that was present here. And by the way, I'm glad that you brought up Keough. In Keough, the defendant, again, this was not a brief incident in that case. The court said in its decision that the defendant engaged in a tug of war with the police officer. Here we have, at most, a momentary pulling away. Again, it's easy to look at the blurbs of these cases and say he stiffened his arm and that was sufficient. But if you look at the facts of those cases, in none of the cases is a mere momentary stiffening of an arm sufficient. And in fact, if you look at the model penal code, the commentary on the model penal code, I think, is instructive here. The courts have cited the model penal code, section 242.2, as being a model for our statute. In the model penal code, it says that this statute is based on a policy to not criminalize flight from arrest or nonviolent resistance thereto. This is so because authorizing criminal sanctions for any effort to avoid arrest would invite grave abuse. Minor acts of evasion and resistance are sufficiently ambiguous to give rise to honest error, sufficiently elusive to encourage false allegations, and sufficiently commonplace to afford general opportunity for discriminatory enforcement. Here we have at most a momentary pulling away, unlike Keough, unlike Grandison, which had 2 officers holding one on each arm and required still 2 more officers.
Does it impact your argument, I'm sorry to interrupt you, but does it impact your argument if we, if the fact finder could have concluded that there were 3 separate instances in which there was an effort by your client to avoid being arrested by withdrawing, pulling away, and the hands under the body? Does that impact your argument at all?
If that was the testimony, absolutely it would impact it. If this was an ongoing, if there was testimony, for instance, in Lender, which is often cited, the struggle went on for 45 seconds to a minute. If there was some evidence that this was an ongoing struggle and more than a momentary jerk back, then that of course would impact this. There was no such testimony here. And once she was on the ground, there is only testimony that she didn't affirmatively offer up her hand in response to a request. There's no testimony that she was pulling away. There's no testimony that she was still.
More testimony that she was keeping her hands under her body intentionally. That wasn't necessarily, it didn't have to be interpreted as she couldn't move them or just opted.
It is unclear. It is unclear whether she, there was testimony that that was the first part of her body that hit the ground when he threw her there. It's unclear whether she didn't or she couldn't move her arms. But what's also clear is that the officer did not grab her arm and she yanked it away. He asked her, and it says, I believe even in the Commonwealth's brief it says, she refused to comply with a verbal order. Refusing to comply and make the officers to affirmatively offer yourself up for arrest, that is not the standard for resisting arrest. And with that, if there are no further questions, I'll rest on my briefing.
Seeing none, thank you.
Thank you.
Good morning. If it may please the court, Elizabeth Mello Marvel for the Commonwealth. Your Honors, in looking at the testimony as it came in regards to this particular juvenile, transcript 2, page 57, goes into detail regarding the officer's interactions with the juvenile, about how she pulled away, how she placed her hands under her body, refused to put her hands behind her back despite repeated commands to do so, and resisted by pulling her hands under her body in an effort, it appears, to shield. That was the testimony that came in to the fact finders for them to determine. I believe the Commonwealth cited to Commonwealth v. Maylott, 2006 case talking about a defendant stiffening his arms, refusing to put his hands behind his back to avoid being handcuffed was an exertion of force to prevent his arrest. In this particular situation, it's the Commonwealth's position that this activity of pulling away from the officer, being on the ground, shielding one's arms underneath the body, refusing to put them behind in order to be handcuffed, to the point where she was told she would be pepper sprayed if she did not comply, and in fact was administered by another officer a 1-second burst, and it was only then that she complied. It's Commonwealth's position that given the elements and the testimony as it came in, that it was sufficient to survive a motion for a required finding in these facts. If the panel has no questions, further questions in regards to that issue or any of the other issues, the Commonwealth would rest on its brief. Thank you.
We now come to the third in the trio of juvenile cases. And just as a reminder, after the conclusion of the argument in this case, we'll be taking our morning recess before resuming with the civil portion of our hearing list. The third case is case number 2022 P888, the Commonwealth versus a juvenile. Again, this case is impounded.
Good morning. May it please the court. Attorney Michelle Menken on behalf of the juvenile AD. This juvenile stands adjudicated delinquent of assault and battery on a police officer as well as resisting arrest.
Attorney Menken, can you please keep your voice up a little bit or pull the microphone closer, or both?
Certainly. I was just pointing out that the adjudications here are for resisting arrest and assault and battery on a police officer in connection with the same events at issue in the two prior
Among these
arguments.
three individuals, this individual was, I suppose, best viewed as the main principal protagonist, right?
Among these three, of course, there was a fourth juvenile who was, I would characterize as the principal.
But he was involved. He made a mad dash to try to get at the officer and engaged in a physical confrontation.
According to Officer Vaughn,
Well, that's the evidence that we are required to. Yes.
that's correct. According to Officer Vaughn, this juvenile AD did approach the scuffle between Officer Parrott and the fourth juvenile who's not at issue, and did approach the proximity of Officer Vaughn. Officer Vaughn asked AD to step back, and AD did not comply, whereupon Officer Vaughn placed his hands on AD and pushed him away forcibly. That was the first physical contact. I'm going to jump to the resisting arrest, if I may, because I think that can be very simply, that issue here, what I'm talking about today, is that the evidence of both resisting and assault and battery on a police officer, which I'll call ABPO, were insufficient as a matter of law. So with respect to the resisting arrest, unlike the two prior juveniles, this juvenile is not challenging Officer Vaughn's basis to arrest him. We're not disputing that an arrest was appropriate in these circumstances, but we are disputing that there was any evidence of resistance by AD after the point at which it was communicated to him that he was being arrested. Notably, there was no testimony. The word resisting was never used. There was no evidence of any conduct by AD whatsoever that would impede the effort to arrest him. Now, the Commonwealth points to inferences that it urges could be drawn from the testimony that Officer Benoit assisted Officer Vaughn, or that Officer Vaughn was, quote, trying to place in handcuffs. And the Commonwealth urges that it can be inferred from that there was some conduct that made it difficult to place him in handcuffs. Excuse me, thank you, by AD, by this juvenile, that impeded the effort to apply handcuffs. And there's no basis for that. This juvenile had officers upon his back. It is not clear that he could have moved his arms into the handcuff position. And just because Officer Benoit assisted Officer Vaughn does not mean that there was a need for such assistance. There just simply was no testimony of that. And even if there were a need, it's not clear that the need was caused by anything that this juvenile did. And that's what I have to say with regard to the resisting arrest. Moving to the ABPO, as I said, the assault and battery on the police officer. The evidence on that count was insufficient because a battery was not proven, and that's essential. The battery must be proven, and it was not
But
here.
there was testimony that he swung at the officer and the officer blocked the blow before it landed.
So the swing, and yes, that is correct statement of the evidence on this topic.
And the block implies, or a rational fact finder could infer that it implies physical contact.
Yes, nonetheless, we're urging that it doesn't undermine the conclusion that this that this delinquency adjudication is unsustainable, and here's why. Number one, with respect to the inference that Your Honor suggests, in context, it is not a foregone conclusion that contact would be inferred from that because it was never argued that way. The prosecutor never...
How else would you block the blow?
I'm sorry?
How else would you block the blow?
Well, perhaps it
What's
meant...
another reasonable understanding of blocking the blow?
I think that these are unusual. I think you're right that that is the ordinary understanding of what that word means. But in this,
It is a permissible interpretation of the testimony, is it not?
it is permissible.
Under Lattimore, I'm really struggling to understand where you're going with this.
Well, let me jump to the more important issue here, which is that word was volunteered by defense counsel. It came out on cross-examination. There was
During the Commonwealth's case, this case is not here on a claim of ineffective assistance of counsel.
well, we have urged
And
that
for purposes of sufficiency, even testimony that was inadmissible counts toward the calculus.
that is the case. However, what we're urging is that we have urged that this was obvious ineffective assistance of counsel, given that defense counsel argued in her motion for directed verdict that there was insufficient evidence on the ABPO because there had been no touching. So clearly, it was antithetical to the theory of defense to offer evidence of a touching. And when it's
That still, even if you are successful on that, which wasn't, you didn't raise a claim of ineffective assistance, but even if that were successful, it would go to a new trial and not to sufficiency.
well,
You understand that, right?
I do understand, but taking a case like Frazino out of this court, and that's 21 Mass App Court 551. When you're arguing that the evidence is insufficient, and it comes up that the directed verdict motion was surmounted because of evidence that defense counsel placed into the calculus, you can consider and afford relief on the basis of ineffective assistance of counsel. When it's
Relief
plain,
of what, in what form?
well, so I think that's where we get to my argument on this, which was articulated in the brief, by the way, that the remedy for ineffective assistance of counsel needs to place the defendant back in the position. It needs to remedy the particular harm. So to place him back in the position, our position is that it's appropriate to basically allow that motion for directed verdict. Alternatively,
Do you have any case that has done that?
I do, the Frazino case that I just cited. So
Where they entered a not guilty based on evidence that was elicited by defense counsel ineffectively?
it was very close. They entered a not guilty based on evidence that would have been excluded were it not for trial counsel's error. And let me say that it should be clear that we have asked this court to conclude that that was ineffective assistance of counsel. And if this court were to say, well, we're not going to give you a directed verdict as a result of that ineffectiveness, we're going to give you the typical remedy, which is a retrial, we still have the argument that the jury was misinstructed on self-defense. So he did have a self-defense, and that would have to be at issue in any retrial. And if there are no further questions on the resisting arrest or assault and battery with a police officer, I'll rest on my brief.
Thank you.
Thank you.
Good morning. If it may please the court, Elizabeth Mello Marvel for the Commonwealth. Your Honors, the Commonwealth's understanding of the juvenile's argument in regards to the sufficiency of the evidence was not to do with ineffective assistance of counsel. It was the claim that the judge inappropriately considered evidence elicited on cross-examination in their decision regarding the motion for directed verdict. That is the Commonwealth's understanding of the juvenile's argument. The Commonwealth's position, it's a basic tenet of evidence, rules of evidence, that testimony is evidence, regardless of what source it comes from. And in looking at various cases, Lattimore, Commonwealth v. Grassi, Keough, as well as Norris, they all talk about the relevant question is whether the evidence would permit a jury to find guilt. When reviewing a motion for required finding, the question is whether, after reviewing the evidence, all of these cases simply talk about the evidence. They do not make any distinction about where that evidence came from, which witness testified to it, whether it was on direct, whether it was on cross. It's simply the evidence. So for those reasons, the Commonwealth believes that would assert that the judge's finding denying that particular motion was appropriate given the evidence that came in, even though some of that evidence, which could be seen to bolster the Commonwealth's case, did come in on cross-examination, but that does not mean that it cannot be considered.
You want to talk a little bit about the erroneous jury instruction?
Yes. Yes, Your Honor. So the jury instruction in regards to self-defense, the judge gave a instruction. She gave the entirety of the non-deadly force instruction.
Do you agree that the instruction was error?
There was an error, and that error was when that particular judge gave the entire instruction to the end. She then added the 6 words afterwards that the Commonwealth concedes should not have been added. There's no disagreement there. That was
in those 6 words, if adhered to by the jury, would require the Commonwealth to disprove only if that the defendant was entitled to self-defense. It can prove only if it would allow the Commonwealth to convict by disproving the risk of great bodily harm or death.
correct. That is correct, Your Honor. But
and there is no question here that there was no serious question of great bodily harm or death.
that is correct.
So the Commonwealth's burden was substantially alleviated by the instruction, by the error in the instruction.
Right? And put another way, the defendant's burden was raised.
Potentially, Your Honor. The court has found in the past, in another case, I did cite to it, where a judge made the same exact error, gave the entirety of the non-deadly force instruction. That was the Aguilar case in 2019, and then inadvertently gave the 6 words at the end, and the court found, assuming arguendo, that the defendant was entitled.
That was an unpublished case, right?
That was an unpublished case.
Any binding precedent that stands for that proposition? Because we routinely hear from the Commonwealth, and we, in fact, routinely follow the adage that the jury are presumed to follow the judge's instructions.
That is.
Or we should make an exception here.
That is correct. I think, however, the court has, again, in an unpublished, but it was.
The panel of this court has done that, but you're suggesting that we should make an exception to the general principle that we presume the jury follows the instructions?
Well,
Why?
I think it's not just a matter of finding an error. I don't think it's just a matter of there was an error and that's it. It's looking at, was there a substantial risk of a miscarriage of justice?
Well, what we've established is that the Commonwealth could meet its burden in the eyes of the jury
Correct.
by disproving that there was any risk of great bodily harm or death. That's easily satisfied on these facts.
It is.
And therefore, the Commonwealth's burden was much lower than it would have been had the 6 words not been included.
Again, Your Honor, I cannot dispute that. It was an error by the judge.
And it had a substantial impact on the jury's evaluation of the evidence on this charge, on self-defense. Right?
Yes. The judge.
Okay, so now we get to what you're about to tell me about why that does not give rise to a substantial risk of a miscarriage of justice.
think the analysis is the evidence in the totality of the circumstances, whether or not that
There
error
was
made.
sufficient evidence to warrant giving the instruction on self-defense, right?
Whether it was minimal or not. You agree with that?
Correct.
So once we are in agreement, this was not a gratuitous self-defense instruction, in other words. Once we are in agreement that the instruction on self-defense was warranted, it's for the jury to determine whether the force used was appropriate in the circumstances. And the instruction they received on that central question substantially alleviated the Commonwealth's burden on these facts.
That is.
I'm not sure how we get to where you want us to go, with all due respect.
Well, I guess then what we're left with is not an analysis of, I guess we're left with the bright line rule then that judges cannot make a mistake and must word for word, lest a situation is created where the burden changes. Because again, that wasn't the decision. I understand it was a different panel. I'm simply stating that there are circumstances that it could be considered that it did not. And that it's not the first time that a panel would be coming to that conclusion depending on the case. I'm conceding it is error. I have no argument that it was not error. It clearly was. It was an inadvertent error on the part of the judge. And when you look at those model jury instructions, she just read the entire thing word for word and then continued on to that next subsection when she should not have. And that's clear.
And it clearly erred to the detriment of the defendant.
Then that's the concern. Yes, Your Honor. If the panel has no further questions, I would rest on my brief. Thank you.
Thank you. All right, we will be in recess. We will resume at 10 minutes past 11.
Floor all rise, please.
We continue our session with the first of the pair of civil cases that we have on the list for hearing this morning. This case is impounded. I'll just remind counsel that not only have we not cleared the courtroom, but we are live streaming, and the cases are, the arguments are archived and available for viewing. So please, please, please refrain from reference to any names. Refer to the participants in the underlying case by their status in the case, mother, father, child, etc. The case is case number 2022 P735. It's a case involving termination of parental rights.
May it please the court, my name is Nora Kane, and I represent
Please start the clock. There we go.
I represent the appellant child number 2, who I will refer to as O. I will be taking 10 minutes and father will be taking 5. One quick housekeeping matter, there is a typo in my brief on page 8. I stated the children were initially removed on 7/14/21, and I meant to say 7/14/17. All other dates are cited correctly. I'd like to begin by talking about my client O. She was 5 years, 8 months old when removed from her parents. She will be 12 this November. She has been in DCF care for 6 years, 2 months. During those 6.2 years, she has been in 12 different placements, with the majority being in a group care setting called St. Anne's Home, where she has been for 5 years and 4 months and remains to date. DCF has been looking for a foster or adoptive home for her for 3.8 years and has been unable to find one. O's 3 younger siblings are all in adoptive or stable foster care. O's position has always been that she wanted to return to her parents. As this court is aware, O's mother passed away suddenly in May of 2023. O's current position is that she is willing to go into foster care, but she does not want to be adopted, and her plan is to reunify with her father either before or once she turns 18. She has 2 legal issues she'd like to raise with this court. The first is that the record lacks clear and convincing evidence that termination is in her best interest, and that the judge's findings regarding visitation are erroneous, and the judge's decision only giving O 2 post-termination and post-adoption visits are not in her best interest. First, in regards to the record lacking clear and convincing evidence that termination is in her best interest.
Talking about father's rights, right? Termination of father's rights.
Correct.
Okay.
Child is not challenging the finding of fitness, just the termination. So her argument is that once judges find a parent unfit, they're required to then see whether termination is in the child's best interest. And the court must consider the child's needs, age, affections, and environment, whether the child has a continuous placement, bonds with another caretaker, and the child's likelihood of being adopted. And that's all from adoption of Thea, adoption of Chad, and adoption of Ramona, which are cited in my brief.
And so if we agree that the likelihood of her being adoption is low, as the judge stated, and was fully cognizant of that, where does that leave us?
So O's argument, and what the judge said was, you're right, she said, I realize that the statistics are very low, and the average for a child her age is 3% chance.
Fully aware of Vito, the case that you were relying on, talked about it in her decision, I think.
Right, and the judge said, I had to do it though because it wasn't safe to send her home. And that's where O argues that there's an error, because the finding of unfitness prevents the child from going home. So termination isn't needed to prevent her from going home. And given the statistically low chances of her being adopted, it doesn't make sense in this case, because we're basically then, what that leaves for the next 6 years is that the department is no longer working with father, and the child is reduced to, if the visits stay the same, 2 visits. And then in 6 years, if an adoptive home is not found and she goes home, as a lot of these children do at 18, then we've wasted the last 6 years. Whereas...
How would the ongoing conditions change if father's rights were not terminated, but the child was still in the custody of the department in foster care for that same period? What else would change?
So what would change is that what's called concurrent planning, and the DCF does this in a lot of cases. If father's rights are not terminated, right now O will stay in the group care setting that she's in, and DCF will continue to look for a foster home or an adoptive home, and O is more than willing to go to a foster home when they find one. In the meantime, the department will be required to continue working with father on the issues that are barrier to reunification.
The judge has incident to the finding of unfitness, evaluated quite extensively the progress that the father, or lack thereof, that the father made through those efforts, and made a determination that the unfitness was likely to persist into the future.
You don't think that was error, do you?
I'm sorry, Your Honor.
You don't think that was error, do you?
So I realize that there is case law that says that when a parent is not making progress, that it is appropriate to terminate.
Well, refusing to engage. I mean, it's a mosaic of issues. It just seems to me that that even if there is a small chance, if there is ever an adoptive placement that is found, it is an incredibly challenging impediment to moving forward, to have then to go back and complete the second part of termination. And if there is no other role for the father to play during the custody, as there would not be, I mean, we'll hear you on the visitation, but the termination piece simply clears the way toward the possibility of adoption, however unlikely that might be.
Well, if I could just respond to that quickly, what can happen, though, is that, say they beat the odds, the 3% odds, and do find an adoptive home, a notice of intent can always be refiled, and we can always have a hearing, and these findings can be applied. And really, the only people put out with that are the adults, not the child. And I'm not
delays the ability to move forward for a considerable period of time.
And is that in the best interest of the child?
Well, so it can delay the finalization of an adoption if that happens.
Maybe beyond the point where it can even occur, depending on how the timeline works out. I mean, we've had these arguments about a permanent, an effective practical orphan, or what, because a child was unlikely to be placed in an adoptive home. But the fact remains that the termination, even where adoption seems exceedingly unlikely, nonetheless serves a valuable purpose in the child's prospects, because things happen, and an adoptive placement might be found. And once it is, it would be in the child's best interest to move forward with that as rapidly as possible and as smoothly as possible.
Well, Your Honor, seeing that there's only 2 minutes left, and I would definitely like to touch on visitation as well, but just quickly, the child would prefer that the 97% chance of what might happen also get some attention, but I will move on to visits.
Before you move on, I just wanted to, this is a serious case, so.
Thank you.
Give it the time that it deserves.
Right.
She's now opening up a little bit to adoption. Is that fair to say?
She's moved back and forth a little. To be honest with you, one of the things that made her hesitant towards adoption was the limits on the visits, hearing that they were going to drop, and that was something that affected her. So the visits are definitely an important issue to her. I would argue that the trial judge's findings on them are erroneous, because she relied heavily on what the visits were like when it was the parents and all 4 children, which is not what the visits would look like. It would be O and her father. She also did not pay much attention to what the visits were like when it was mother, father, and O, which went very well. She was extremely excited, eager, and couldn't wait to see her parents. And given how little, she also is the child with the least amount of visits. Her younger brothers have 3. She has 2.
She has more problems, I get it. The mom did most of the engagement at the visits. Would you agree with that?
Definitely the visits when all 4 children were there, but I think the evidence shows that when it was mother, father, and O, that he was equally involved in them. It was really, the visits were very different when all 4 children were there for sure, and I don't think those are the appropriate visits to look at for a decision moving forward.
Would the visits remain supervised?
Yes, the visits are supervised.
At present, what is the child's ability to seek modification of the visitation schedule as the judge set it, given the circumstances today?
She did try. That's in that case was the appeal of that was consolidated with this case. She tried back in August of 2022 to have the number increased, and the court specifically denied it. So.
And is there a next opportunity? Is there an interval that
she
has
can,
to
but the court seemed very clear that she was not willing to consider it. And you know, these visits, they're all she has right now, and they're positive. And the number can be changed in the future if need be. It's really all she has to look forward to, and she would like it sent back so that she has the assurance of the court. Because right now she doesn't have the assurance that when it goes back, she's going to get more. She already tried, and it was denied.
The child, I'm not certain I remember this correctly, but is currently having monthly visits at the department's discretion, or was at least as of the time of?
At the time that I filed, it was monthly, and I believe right now it's every other month, so 6 a year.
Thank you.
Oh, really? It's every other month and not monthly now?
Right now, they're every other month. They were reduced. The department can reduce them down to 2, and even 2 isn't secure for her because it says subject to change based on the recommendation of her treatment team as she transitions to a pre-adoptive home.
So she has 2 as ordered by the court, and then every other month.
Two subject to change is the floor.
By DCF.
2 subject to change is the floor, and right now DCF is giving, that's post-adoption and post-termination. DCF is giving 6 right now post-termination.
And the court's reasoning was that the visits weren't really to strengthen the bond with the parent, but were to assist the child in kind of a gradual moving on to their new home life. What do you say to that?
She has no new home to move on to. She doesn't even have a foster home to move on to, let alone a pre-adoptive home to move on to. So yes, in cases where children actually have a home, that makes sense. But she doesn't even have a foster home. And the fact that they can't find a foster home, that's rare. Finding pre-adoptive homes, that happens, but they can't even find a foster home. So she has no one else to visit with, to come watch her plays, to play games with, to get gifts from. She really looks forward to these. And the evidence is that they're positives. So when we take away something like this that's positive from a child, they just get more resentful towards their situation. And I don't see the harm in allowing her to continue visiting when they're positive. She's saying she'll go to a foster home. It's not.
How many visits do you think were appropriate?
I think when we just recently met with her, she said that she would like them back at the 12 monthly that they were. But she would take the 6. 2 she is not happy with. 2 is too few. Especially post-termination when there's no other option.
All right, thank you.
Thank you.
We'll hear from counsel for the father.
Thank you, Your Honor. May it please the court, my name is Michael Penta, and I represent the appellant father. I'd first like to start with Chief Justice's green question and concern regarding the permanency and delay of a hypothetical child, because this is a child-specific analysis, and this child is specifically institutionalized unnecessarily. What the process realistically looks like for if things were to change for her, if my client's rights were reinstated, the department would still have to first find a foster home, which they have been unable to do, much less an adoptive.
I can't hear you very well.
They would still have to find, they may still have to find a foster home, which they've been able to do, much less an adoptive home. That child must be placed there for 6 months before they can move forward with the proceedings to terminate parental rights. And there's a mechanism built into the care and protection statutes for review and reindetermination if circumstances do change. But in this child's specific circumstances, she has been in a situation where a younger child is more likely to find a suitable foster home and adoptive home, and will soon be able to consent to whether or not she can be adopted. So these are all factors I hope this court will consider from a child's perspective analysis, as opposed to the theory that freeing a child for adoption in general may lessen or increase the panel of people available for adoption. And I do also want to point out that this is not, my client's Sharkham is not the typical type that this panel or this court sees. He did not have any substance abuse issues. He did not have any mental health issues. He did not have any cognitive limitations.
You know what PTSD meant, right?
Well, I don't think that there was no.
And that's what the number one prognosis of the child is, and he didn't have any understanding of what that meant or how it impacted the
Well,
child.
that's probably from an educational standpoint, not less a cognitive or mental health issue. Because to keep in mind,
Talking about overall parental fitness. That's what you're addressing right now, right?
in whether or not it was an abuse of discretion to terminate his parental rights, whether that was too draconian of a measure specifically for child 2, given the totality of the circumstances for that child. Now, in perspective, the children were in a very different situation at the time of the removal. My client was just in recovery from a 4-year battle with cancer. He was unemployed. He was dealing with 5 children from the ages of 8 months to 16, I think, or 13 or 14 years old, all of whom suffered from various medical maladies.
Is he presently in permanent housing?
As far as last I spoke with him, they're in housing. Yes.
I don't know I'm sorry, I didn't hear.
He does have housing. Yes.
What's that mean?
I'll be honest with you, I don't know the answer as of today.
That was a big issue, wasn't it?
I think it was made, well, we don't terminate parental rights based
Not
on.
standing alone, but housing instability was a factor in the decision
Maybe rendering him unfit, but not for the draconian measure or the extreme step of terminating parental rights. And the record does.
So are you addressing termination or are you addressing unfitness and termination? I just want to be clear on what it is you're arguing.
I argue in my brief, and we're not conceding that the evidence, the judge's findings, that he was currently unfit, but I certainly am arguing that even if they were, that this panel agrees with the judge that there was current unfitness, that the measure of terminating his parental rights with respect to child 2 especially was a step too far. Because as the record shows that with the exception of housing, which they testify they're on the precipice of securing, if we look at looking at the record as a whole, the issues were what many people face. They have bad credit. They couldn't afford first and last month's deposits, but they were paying.
We're not talking about his financial stability, I get that, but we're talking about his ability to get her to the appointments. I think the briefs say that it was his job primarily to transport her back and forth to her medical appointments, and that wasn't happening with any regularity.
Well, with respect to child 2, I think the only missed appointment was a specialist appointment. They were up to date medically.
That was a big one, right?
It was a big one, but I mean, again, missed a medical appointment is a much isolated incident as opposed to a progression of missed appointments. And again, this case started out with 5 children, and the 2 younger boys, which he understood were too much for him to handle, that they voluntarily surrendered their rights to the 2 younger children because of their significant medical needs. At the time of trial, the oldest child, child 2, I should say, or O, as it's often being referred to, was taking 1 pill at night to go to sleep. So we don't want to just measure my clients in a vacuum. You also have to measure the child themselves too and the progress that they have made. And maybe those overlaps render a much different environment than they were at the time the child was removed.
Does mother's passing in any way impact your argument?
In fact, in some respects, it may strengthen it because she had some shortcomings as well. She did have mental health issues. She did have substance abuse issues. My client does, as the record will show, has a network of support between his mother and other relatives. So I don't believe her passing makes my client's position weaker. And if it does, it should be remanded for that decision, not for...
What other relatives are you referring to? I saw that the
grandmother.
The grandmother's involved a bit.
The grandmother was involved a lot.
Beyond that, I didn't see much other family support. What are you?
They were co-parenting for the most part, but they did have family support. But with the passing of what wasn't his wife, but they were in a very lengthy relationship, he certainly turns to his family for comfort and support. And I'm sure he would do the same if he were given a chance to work towards getting custody of his daughter. And I do point out that the objective at the time, I know, I'm sorry if I ran out, but I just have one more point to make, is that, there also is an opportunity to put forth a very substantial reunification plan, too, that the judge has at their disposal. It's not simply that you win and the case goes on. If the judge found the client unfit, the parents unfit, There was certainly at the time making progress at the time the trial concluded. The therapist says they've been very consistent in 6 months. They've made progress. The judge is finding that my client could not even wrap his head around the fact that his daughter was sexually abused at all is not supported by the record. The social worker said they got beyond that point. The therapist said they got beyond that point. My client acknowledged he got beyond that point. And so when the department put up the barriers to therapy, saying our goal is adoption and this is what we're working on, they're not working towards reunification. They really aren't at that point. And the therapy was designed not for reunification. So I just know I have out of time. I don't know if the panel has any additional questions. Those are the rest of my brief. Thank you.
We'll hear from the department. I understand you will use 10 minutes and leave 5 minutes for the other children.
Yes, Chief Justice.
Or the other child.
Good morning, members of the panel. May it please the court. I'm Kristen Braithwaite, Assistant General Counsel for the Department of Children and Families, and I'm here today asking you to affirm the decrees issued by the lower court. Father argues that it was improper for the court to attach weight to his refusal to accept his son's sexual assault of his daughters, where the court didn't prove the sexual assault, that the court erred by failing to account for the change in his family milieu and by attaching too much weight to his failure to comply with his action plan, and that as such there was inadequate evidence to show clearly and convincingly that he was unfit to parent his daughters. In fact, the evidence was abundant, and none of these arguments warrant reversal. And while the older daughter seeks return to her father's custody and increased visitation, the record supports the court's conclusion that termination and the visitation order were in the best interest of the girls. These children were removed from their parents' care after years of the department working to stabilize this family around verbal and physical abuse, unsanitary conditions in the home, poor hygiene, domestic disputes, and medical neglect.
Can you tell me, speak directly to the negative impact or why it's not in the best interest of the child to have a couple more visits with dad throughout the year?
Well, with regards to the oldest child, I'll call her O, there was evidence in the record that the visits were not, well, strike that. There was evidence in the record that O enjoyed the visits, but also that they were traumatic and caused chaos for her. One of the bigger issues in this case that I believe the panel has been addressing so far is the likelihood of adoption that O has moving forward. And one of the biggest things that will help her become more adoptable is if she can find stability and if she can enter into a mental health state where she is more easily able to transition into a family. The evidence has shown that visits with father have not been as good as the record has been reflected by my brother and sister. And in fact, even though there's this argument that the milieu has changed and therefore visits were better, the court found, based on the record evidence before it, that visits even with just O were not as good as made out to be earlier. They were often requiring redirection. There was often conversation that was inappropriate. At times it would become dysregulating for O. She would have to at times end early. And so it is true that she would look forward to visits. It is true that she would have some enjoyment from these visits, but it is also true that they would have a negative, detrimental impact on her mental health. I would also add, with regards to visits, father has brought attention to the fact that this decreased milieu would help in things. But in fact, when there were no children in father's custody, he still failed to attend a number of visits. I could talk about the therapeutic ones, but if we're simply talking about the social visits, father had an opportunity to avail himself of multiple visits, which he did not use. He was often late. The record showed that this was so distressing for O that she would be pacing the windows, anxious, waiting to see if he would arrive. He had the opportunity to call her. I believe it was every Sunday. He did not avail himself of most, if any, of those opportunities. And so I would argue that by increasing visits, while O may want them, father has not evidenced an ability to be reliable in meeting those visits. And far worse than not having a visit scheduled for O would be that she would expect a visit, want a visit, look forward to a visit, and be let down yet again.
Was she receiving, did the department have her getting a monthly visits?
The department was having her get monthly visits. They were dropped down to 2 times, to every other month.
And can you share what the reasoning was for that?
I wasn't privy to the reasoning. It was clinical and in a different area, but my understanding is that there was concern that O was exhibiting enhanced dysregulation after visits. They weren't all going smoothly. And that while it isn't ideal for her to remain in St. Anne's. She had found routine, she had found structure, she was functioning well, and the visits would set her back to a degree. The goal at this point for the department is to get her into a foster home, to find her a pre-adoptive family, and to do that is going to require some baseline of regulation, and the visits were not advancing that. Shall I move on? Okay. I want to address something that came up as a significant part of Father's brief, which is this notion that he was punished for not being willing to accept that his son had been the abuser of his daughters. And I would also like to tie that into his indication that he shouldn't be penalized for failing to comply with his action plan, as he felt those services weren't relevant. I would like to indicate that Father was given many opportunities to engage in therapeutic services that may have advanced him towards meeting the needs of his children, whether or not he believed that his son was the perpetrator of their abuse. Father's ability to protect his children from abuse requires an understanding of the abuse and also of potential threats. I briefly direct the panel to Adoption of Mary, where the Supreme Judicial Court had occasion to evaluate the negative impact on children of a parent remaining in contact with an abuser. The facts were different. The abuser in that case was a romantic partner. But here in this instance, Father testified not only that his son was at times staying at the same hotel where he and his then living wife were staying, but also that he was seeing his son 3 to 4 times per month. Now, while I am not suggesting that Father had to make the Hobson's choice of whether he would see his son ever again or see his daughter, Father chose not to take part in the offered safety planning. And in order for these children to have any ability to feel safety with Father, they needed to know that they were not going to encounter the individual that they communicated was their abuser. So while Father was not required to say, yes, this was your abuser, Father was required to take actions to ensure that if he were going to be with the children, they would not feel that they were with their abuser.
Did the son go into I'm going to call it a 2-year treatment program for sex offenders following removal from the house? Or after he left the house, did that happen with the son?
It did, but when he aged out, he left, is my understanding.
And he went into that, and that was completely independent of the alleged interaction with his sisters, is that right, or is that not right?
I don't believe that completely independent would be fair to say. I think there was an overlap. He certainly did not acknowledge, I did this and therefore I will go, but the constellation of events that got him there were not unrelated to the accusations that came. I am familiar that the panel is well read on the record, but when this allegation was first brought to T, I will call him, although he did not acknowledge it had happened, he began to sob. There are indications that he also experienced a lot of trauma as a result of what happened, and keeping separation between these children is vital for all of them. But with regards to the notion that somehow not terminating rights, or strike that terminating rights was draconian, I would like to point out that by not terminating rights, Father would have the opportunity to go back and seek a review and redetermination every 6 months. And in order to do that, he would have to show that there were changes in his circumstances that warranted such a review and determination. But were that allowed, the children would be the ones to suffer. They would be put back through this event. And so there are various reasons why our case law tells us that termination can be best for our children. It can get them stability. It is absolutely crucial, and the trial judge weighed in on it, and you have weighed in on it as well, that it also frees a path towards adoption, but it also prevents this from being relitigated and from this child's trauma being a source of testimony, of dispute. And while Father continues to dispute the version of events as articulated by the children, that has the potential to be devastating to these children. And he does it allegedly in the name of wanting to care for them, but he didn't. And this part is important. I'm not reflecting on whether it would be good or bad for them. That is beyond my pay grade. But the department had an action plan that involved individual therapy, that involved father meeting with O's trauma therapist, not only with O, but also independently, so that he could come up with a safety plan. This brings us back to the notion of whether it was T or not who was the abuser. The children, the girls, needed safety. Father didn't avail himself of the opportunity to obtain that safety for these girls. Had he done so, perhaps it would be in a different place. Perhaps there would have been a way around it. But as it stands right now, Father has made zero progress towards communicating to this panel, to the department, to anyone, how he would ensure that his children, who clearly suffered trauma, even if we can't define what that was, they came into the department's custody with enuresis, night terrors, screaming things such as, "Get off me, Mom, stop, please don't touch me." There is no question these children were traumatized. There is no question that Father was offered numerous pathways to address how he could meet the children's needs, regardless of what their trauma was, and he rejected them time and time again over a course of years. I'm happy to go on, but I'm aware my time has concluded.
Thank you.
Thank you very much.
Good morning. May it please the court, I am attorney Catherine Foster on behalf of child number 1.
Please keep your voice up.
Oh, yes. Child number 1 has changed positions several times in this case and indeed filed a hybrid brief requesting additional visits. But after her mother's death earlier this summer, her position is that she no longer challenges the court's visitation order with regard to her father, which would be 2 visits per year. Her relationship with her father was safe when it was mediated and facilitated by her mother. May
I just stop you there for a moment, just so that I have an understanding of what the current state of play is. The order, she's no longer challenging the order for 2 visits a year. How many visits are currently taking place between father and this child?
At the time, as has been represented by my brother and sister counsel, there are every other month visits with
So the
father.
same visitation schedule for this child as for the other child. It's not necessarily the case that would be, but you're telling us that it is every other month.
Yes, the visits are, all together. All of the siblings visit every month, except, well, I'll leave it. The siblings visit each month. Every other month, the visit includes father.
Visits include all of them together?
Yes, all of the ones that are visiting,
Okay,
yes.
thank you.
Yeah. So when both parents played their established roles in the visits, mother was able to prioritize child number 1 and her interests and her safety. But without her mother, she's left with a parent who never believed her disclosures, who chose and continues to choose his adult son over his adolescent daughter.
As you stand here today, you're strictly in the role of appellee.
I am a strict appellee, my client is, who requests that this court affirm the decision in its entirety. But my client also supports her sister because her sister is so differently situated, and in the same way that was somewhat overlooked by the trial court.
Case is impounded.
Oh, I'm so sorry. In the same way that this child was somewhat overlooked by the trial court, each child deserves to have an individualized review by this court. And
by the way, we've heard arguments from the other child. Please confine your advocacy to your child.
If the panel has no other further questions, I'll rest on my brief. With
Thank you.
apologies.
This case is submitted. We move to the 6th and final case on our hearing list this morning, case number 2023 P47, Gregory P. White versus Robert Keough and another.
Good morning, Your Honor. May it please the court. My name is Attorney Herbert W. Boudreaux, Jr., and I represent the appellant in this matter, Robert Keough. This appeal is brought as a result of a probate proceeding in the Middlesex County Probate and Family Court, which you're aware of. And it involves the contest over two wills by Mary Finn, the decedent. One will was admitted to probate with Mr. Keough being the petitioner and being appointed the personal representative on January 13th, 2019. Subsequently, on April 16, 2019, Judge White filed a subsequent will for probate and requested that he be appointed the personal representative of the estate and also to vacate the prior finding of the court of the will and the appointment of Mr. Keough. Procedurally, we went through summary judgment motions and a motion to dismiss, which were both, all were denied by the probate court judge. And then subsequently, it was set for trial. We ended up filing a motion to be, for it to be decided on the pleadings. And as a result of that, the probate court judge allowed the petition for Mr. White to be allowed and vacated the petition that appointed Mr. Keough, the personal representative.
Attorney Boudreaux, am I understanding correctly that your client's position is that there was the motion to probate the later will, petition, included a petition to vacate the older one in one document, correct?
That is correct. Basically, at the end of the petition for formal, just above the signature line, there was a request to vacate the prior.
And that was, in your view, a petition to vacate, just filed as part of the same document, correct?
My position is that you cannot do it that way. That according to the probate law, section 190B, section 3410, and section 3412, is that you have to have a separate petition to vacate filed before allowed before the court can entertain another petition for probate of the will.
I'm sorry, I didn't mean to cut you off. Do you mean that is the point of your argument that they need to be physically two separate filings?
I do, Your Honor.
Okay. And where do you get that particular distinction, the requirement of two separate filings?
I get that distinction under section 3410, which says that no petition may be filed until a prior one has been vacated, and then under 3412, it talks about how it may be then proceed.
Doesn't 3-410 say no petition may be entertained? Until it doesn't say filed, does it? It says entertained.
I am equating entertained with being filed.
If entertained meant for the purposes of argument, meant considered and decided, for example, would that require a separate piece of paper to be filed for each petition?
I guess I don't understand the court's question. Are you asking?
In this case, let me put it in a slightly different fashion. In this case, there is no indication that the court applied any substantive consideration of the motion to probate the second will, the request to probate the second will, before ruling on the motion to vacate. Is that correct?
That is correct, Your Honor.
Okay. And the distinction I understand Judge Hand's questions to be going toward is the distinction between entertain in the sense of applying substantive consideration to, and the position that you seem to be arguing that suggests that entertained means it may not be presented in a filing, whether that filing is considered or not.
Well, I do think that there is a I think that with the terminology entertained, I think that doesn't have it. I think that that still means that it has to be done before the matter
question
is vacated.
of vacating has to be determined as a prerequisite, right?
That is correct.
And was
Yes.
that done here?
No, it was done simultaneously. Because at the same time that the judge entered the allowance of the petition, he vacated the prior order.
Well, the only way he could allow the second order is to vacate the first, right?
That is correct.
So it had to have been done first.
I'm sorry, I missed that, Your Honor.
So it had to have been addressed first. I
That
mean, he may have read them at the same time, but the act had to be to vacate before you could permit the second act, right?
That is my position.
What's your best case for your statutory interpretation of the language?
Is that the petitioner should have filed a general...
Asking for a decided case, appellate precedent authority.
Oh, I'm sorry, Leighton and Hallstrom, and also the Wittes case. Both of those, one of which you said on the panel, Your Honor, saying that the statutory scheme has to be strictly followed, and then the Wittes one basically followed up and confirmed what the court decided in the Leighton case.
Well, but saying that the statutory scheme has to be strictly followed presumes that that this didn't follow the statutory scheme, and that's the central question here, isn't it? What is the best case? I think if I understood, and I always hesitate when I'm reframing my colleagues' questions, as I did a moment ago with Judge Hand, but I understood Judge Desmond to be asking, what is the best case that you can point us to that would apply the interpretation to the statute that you would have us apply? Because I have to say, from my perspective, when I read the statute, it is not crystal clear to me that the language requires separate proceedings in the manner that you've described as a jurisdictional prerequisite.
I could not find any case that was directly on point that said that you had to do A before you could do B.
What would you say to the challenge that the argument you're urging on us elevates form over substance?
And sometimes under the law, that has to take precedence.
Understood, where the language is inescapable.
Right, and
But the language of this statute, for some of the reasons that we've discussed, does not lead inescapably to that conclusion, at least not to my eyes.
Well, and I respect the court's position, but I also feel that the way that 410 is written, and then also it basically states that that's the way it should be done. If you follow the Wittes case, they did in fact file a separate petition in order to do it. As part of that procedure in that case, because I did look up the underlying case and the pleadings in the court, and it was a general petition. I would say that a general petition should have been filed again in this case, and simultaneously at that point in time.
When we're charged to interpret the provisions of a statute, we start obviously with the language of the statute, but we also, if there's any question about how language should be interpreted, we are admonished to consider what the purposes of the statute were. What objective was the statute designed to address, and whether any party would suffer prejudice that was outside the purview of what the statute was trying to accomplish if we were to adopt a different interpretation. So let me ask you, how is it that the interpretation that you are seeking to press furthers the the presumed purpose of this statute?
Well, the presumed purpose of the statute is under I believe it's 103, Your Honor, where it sets forth what the purposes in this, of the statute is. I'm sorry, it's 310. I apologize. It's section 1102. Under that, to simply clarify the law concerning the affairs of the defendants and missing persons, to simplify them is to try and get the probate of the will and also, obviously, the assets that would flow either under a will or under the intestacy down to the people who are deserving of them or under the will of the devotees, promote a speedy and efficient system for liquidating. That's what I just said.
Right. So one of the goals is a smooth and efficient determination of the rights of all interested parties, right?
Correct.
Okay. And another one, I suppose, if we look specifically at the provision that is at the center of your argument, we ought not to be mucking around with competing wills until if we've got a final decree that has authorized or approved another will. So we're not going to take up the question of someone else's will, someone else's claim to a will, if there's been a final adjudication of a prior will. So I'm trying to understand how the requirement that you are seeking to impose on this statute advances the goal of not interfering with an adjudicated will until after it's been vacated, or how it is more efficient in terms of reaching timely and orderly disposition of the rights of the parties.
Well, to file the petition to vacate would set up the matter on whether or not it is or it is not a.
Well, that was done here, right? There was a petition to vacate.
No, it was not. It was a petition.
There was a request to vacate within the petition to approve the will.
Right, but it was not a petition to vacate. It was a request under a petition for formal.
Well, now I get back to that question I asked you earlier about form over substance, because there was a request within a petition to vacate the prior will, right?
Right.
Okay.
And yeah, it
So
comes.
how does filing two pieces of paper, two separate actions, improve efficiency as compared to doing both in the same one, so long as the adjudication of the subsequent will is not undertaken, not entertained, not to put too fine a point on it, until after the petition to vacate is determined?
I'm only going upon the fact that my reading of the statute says that it should be done in advance of the matter being vacated. I'll strike that the petition to vacate should be advanced at the same time separately than the petition for the formal entry of the will in the appointment of a new personal representative.
If he had, rather than called it a request to vacate within that same petition, but instead said, also included here as a petition to vacate, still in the same document, would you have the same argument?
I would, because it's a petition for the formal adjudication of the will and the appointment of the personal representative. It's not a petition to vacate. Petition to vacate is a separate and distinct thing, and I understand that you file a motion. It doesn't matter what the heading says. It's what it's really trying to do. I do understand that rule of law, but I'm saying here that it's not a motion. It's a petition. It's a statutory prerequisite for the new petition to be adjudicated. You have to take care of the old one first, and then you can adjudicate on the new one. And I do understand the court's argument or suggestion that, well, if he vacated it first under the formal petition, does it still do the job? I say no, because I still say that you need that separate and distinct petition in order to be able to go to the second step. Thank you for your time, Your Honor.
Good morning. Thank you for the opportunity to address the court this morning. My name is Timothy White, and I would ask the court to begin its analysis in this case with a brief review of General Laws Chapter 190B, 102, which sets forth the purposes, the policies, and the rule of construction for the MUPC. Section A states, "This chapter shall be liberally construed and applied to promote the underlying purposes and policies of the MUPC." Section B sets forth those underlying purposes and policies, including to make effective the intent of the decedent in the distribution of their estate, to simplify and to promote a speedy and efficient system. Now, in a recent SJC case, in the matter of the estate of Patricia Ann Slavin, the court not only cited the importance of the above language when dealing with the MUPC, it actually went further and stated that there's a key attribute to Article 3 of the MUPC, and that's flexibility. In that particular case, the court was flexible in allowing a voluntary administration appointment to qualify as an appointment to allow a late-filed petition. With the above in mind, we look at appellant's claim that White had to first file a separate petition to vacate, second, prosecute it until the entry of a final decree or order, and then third, then and only then, file and prosecute the petition to probate. Well, it's not what Sections 410 or 412 says. Requiring dual proceedings, one after the other, is contrary to the speedy and efficient distribution policy of the MUPC, and it's also contrary to the previously noted Slavin ruling requiring flexibility when dealing with the MUPC. Now, for example, Section 412 states, I quote, "The court shall entertain a petition for vacation of its order and probate of another will," close quote, "conditioned on an absolute deadline that the petition be filed within 12 months. Now, appellant would add language to Section 412, specifically the word separate. So the statute would now read, "The court shall entertain a separate petition to vacate," and after add the phrase, "prosecute to a final order, and once relief is granted, then file the petition to probate the will." Now, as a matter of law, courts do not add languages to statutes. We cited in our brief the DeMacy case. In the recent Slavin case I just mentioned, cited the case Z. Kit Mui. Requiring dual proceedings would be inefficient, would slow the probate process, it's illogical, and is contrary to the express purposes and policies set forth in the MUPC. Now, White filed the petition to probate and the petition to vacate within 4 months of the previous order, and therefore satisfied the absolute deadline of 12 months set forth in the statute. Now, the probate court incorporated White's filing with the earlier Keough filing, adopting the same docket number. The parties then engaged in discovery on this petition for over a year, recognizing that we were prosecuting a request to have the earlier probate appointment vacated and the more recent will allowed. And then the judge heard the facts, analyzed the law, and made his decision that the filing satisfied the statute. Now, I think it's noteworthy that the petition to vacate would only be granted if the new will was properly executed, and in this case, for example, there was a suggestion of undue influence, that it was executed without undue influence. Now, finally, returning to the purposes and policies of the MUPC, if we're to follow those policies set forth in the statute and respect Mary Finn's final wishes in the distribution of her estate, in accordance with her wishes, I'd ask this court to uphold the trial court's ruling. And I would also ask the court to award reasonable appellate fees for the reasons set forth in our brief, noting that the appellant's initial claim of undue influence was found to be based on pure speculation. And the late claim need for dual proceedings is so lacking in merit that the beneficiaries should not be forced to bear the cost of this appeal. And with that, I'll take any questions from the court.
Seeing none?
I'm done.
Thank you both for your argument. The case is submitted. That concludes the argument in this case. It concludes the argument in all 6 of our cases today, and we are in recess.